Good morning again. My name is Andrew Cohen.
And I'm Shalev Roisman.
We are the co-organizers of the National Constitutional Law Workshop Series, of which today's event is the first installment. The series is sponsored by the REHNQUIST Center for the Constitutional Structures of Government at the University of Arizona's James E. Rogers College of Law. And we're delighted to welcome all of you here this morning and delighted to have Aziz from the University of Chicago here with us to present our first talk of the semester and of the series. We'll have other talks, one a month for the remainder of this academic year, and I'll have a reminder about the next talk, February's talk, at the end of today's session. Aziz is going to talk to us this morning about his very interesting new book project entitled, at least tentatively, The Collapse of Constitutional Remedies. He will speak for about 15 minutes, and then I will keep the queue. We'll operate more or less like an ordinary faculty workshop. If you have a question, please type Q and a short description of the subject of your question in the public chat, and I'll make some effort to group the questions by subject as we go to the extent feasible. Please remember to keep your microphones muted unless and until you are called on to ask your question, and please remember to mute your microphones after you have asked your question. With that, I'll turn things over to Aziz.
Thanks, Andrew, and thank you, Shala, for the extremely kind invitation. I'm honored to be part of this series. If the series required any additional advertisement or enticement for those who Andrew and Shala might choose to invite in the future, I'll say that this morning I received, I think, what are the best comments that I've had on a manuscript for many, many moons from the organizers, for which I'm extremely grateful. So if you're looking for terrific feedback on a project, Andrew and Shala have set up a venue in which you'll get that right off the bat. So thank you very much to everyone who's on the call for engaging with a project that is partial in a couple of different sentences. Partial in the sense that you have two chapters of a book that's obviously longer. And it's partial in the sense that it likely falls between two stools. It likely falls between the kind of full-on academic work that grapples with the doctrine in a more granular way, and on the other hand, a work that is perhaps suited to a general audience. It's probably at a level of sophistication or a level of detail that's too high for that, at least at the moment. The aim of the manuscript is to place our present difficulty of securing judicial remedies for unlawful, unconstitutional state violence in a larger historical and structural lens. So what I hope that readers get out of the book is an understanding and appreciation of how law creates institutions, how those institutions channel and then are shaped by political and material forces, and how the combination of legal templates and historical development precipitates in the doctrines that we as law professors teach as autonomous forms. Today, as many of you, of course, know, an individual litigant seeking a remedy for unlawful, unconstitutional state violence by a government official, faces a warren of hurdles. The most famous or well-known of these now is qualified immunity, but the basic structure of qualified immunity as a hurdle to a constitutional remedy is reiterated. It's reiterated in the form of the good faith rule that governs exclusion of unconstitutionally obtained evidence. It's reiterated in the form of the gatekeeping rule for state court prisoners seeking habeas relief in a provision of federal law commonly known as 2254D. It's also echoed, if not quite reiterated, in the barriers to discovery of evidence concerning the government officials' bad faith or improper motive. And finally, it's not just reiterated, but compounded in the limits to rights of action against federal government officials. In contrast, litigants bringing structural challenges pursuant to the separation of powers or federalism commonly face no such barriers to their suit. To the contrary, it is often the case that an individual plaintiff or litigant seeking relief on the basis of a structural constitutional argument does not even need to trace a connection between the structural constitutional flaw they allege and the particular kind of harm that they experience. This combination has regressive effects. It obviously leaves individuals vulnerable to unlawful violence while allowing regulated actors what is in effect a third bite of the apple after the House and the Senate have considered a piece of legislation. So a simple explanation for this state of affairs would be to look at the composition of the federal bench. It would be possible to imagine a Supreme Court comprised of Justice Sotomayors and Justice Marshalls that would behave quite differently. But I think this is a question-begging solution or a question-begging explanation for our current state of affairs. Why is it that the composition of the bench matters so much? How does the content of the law come in the first instance to be so porous to the springing and shifting preferences of the judiciary? So as a way of thinking about that question, or as a frame for that question, the book threads a path from the design of the 1787 Constitution, in particular Article 3, through to the gradual accumulation of institutional power by federal judicial actors in the 18th, 19th, and 20th centuries, up to the present day constellation of doctrine. That is, the aim of the book is to link together, to conjoin constitutional design, institutional history, and present day doctrine. The intellectual coordinates for that effort, though, are less the doctrine-focused approach of the modern classroom, and much more the approach of the political scientists within the American Political Development, or APD school. So the extract of the book that I shared, which comprises an introduction, chapters 1 and 2, covers the constitutional design and the early institutional history of the judiciary. Later chapters document the ebb and flow of remedies, particularly through the mid and late 20th century. They also extend and deepen the structural critique I offered, or I mentioned earlier, of the present arrangement for remediation as regressive in character. Let me say a word about chapters 1 and chapters 2, and then let me turn things over to questions. So the chapter on constitutional design of the judiciary underscores the assumptions that animated the framers' choice in respect to an independent judiciary. The most important of these choices concern the decision to protect independence, not in its institutional form, but it's in its individual form. The institutional judiciary, in contrast to the mandatory jurisdiction one observes in other constitutions, is relatively weak. Insofar as the Constitution protects individual level autonomy of judges, it does through by an ex post rather than an ex ante strategy. It relies, that is, on after the fact protections of tenure and salary, rather than on the depoliticized selection mechanisms that are employed in several American states and in other constitutions. This choice to opt for individual rather than institutional checks and to opt for ex post rather than ex ante checks is illuminated by the assumptions that are set forth within the ratification debates. The assumptions of the framing design for Article 3 rested upon the notion that there would be a limited supply of qualified candidates for judges, and that the selection process in the presidency and the Senate would not be dominated by factional forces. Both of these assumptions, of course, turn out not to prevail. Right? They both fail during the early republic. Indeed, the assumption of separation of powers rather than parties famously fails because of the very actors, Hamilton and Madison, that relied upon the assumption in the first instance in their constitutional design. Right? The result of this failure of assumptions is a judiciary that is far more open to the springing and shifting preferences of judges than the designers of Article 3 intended. Chapter 2 turns to the history of the federal courts in the early republic as a way of emphasizing institutional weakness in particular. I emphasize Stewart v. Laird rather than Marbury v. Madison as a seminal, as a touchstone case for understanding the status and relationship of the federal courts to the political branches, the elected branches in the early republic. Stewart underscores the weakness as an institution of the judiciary, particularly prior to the 1870s. To be sure, I flag some areas in which the federal courts were active with respect to the enforcement of constitutional rights. Some of the admiralty cases that Jim Fander has written about, some of the contract clause cases that Anne Woolhandler has brilliantly expounded, and some of the cases under the Fugitive Slave Acts are instances of constitutional rights enforcement in one form or another. But it is not until the 1870s that a political coalition comes to the fore in the elected branches, a Republican alliance or a Republican coalition that has the incentive and the opportunity to shore up the institutional capacity of the federal courts. This institutional thickening that takes place from 1876 onwards creates opportunities for political entrepreneurship. And I emphasize the role of Chief Justice Taft as a policy entrepreneur at a moment at which institutional changes were creating opportunities for such individual action. So the section that you read is supposed to leave the reader in a position where the federal courts have advanced to a state of reasonable autonomy, particularly in relation to their status during the first 60 years of the Republic, and where the porousness of the selection process for the federal bench remains as a lever for political actors. The balance of the book then plays out the way that this set of institutional dispensations creates a backdrop for the rise and the fall of individual level remedies over the course of the mid and late 20th century. So I look forward to your questions, and I'm delighted to talk about either anything that's in the sections that you read or anything that's in the parts of the book that I've alluded to but not shared.
We're happy to open things up to questions. I see that Shalev is in the queue, and I'm happy to let him ask the first one, but we'd also be happy to open this up to the audience initially if any of you have questions to get us started. Shalev,
Great, thank you.
Kick us off, and others can put your questions in the chat.
Great. So thanks so much, Aziz, for joining us, and thanks to all of you for coming. And thanks for the great presentation. My question is a bit about the framing. It's an institutional question, and it's a bit about the framing of the title. At least we didn't really get to this part in the excerpts you gave us, but the book is called "The Collapse of Constitutional Remedies," and I was kind of wondering, like, collapsing from what? And so the basic question is, was there ever a time when the courts really played the robust role of remediating rights violations for the kind of less powerful members of society that you're concerned about? And I think part of what the excerpts do so well is call into question the ability of courts as an institution to play that role at all. So because they're set up as so reliant on these other actors for power, for funding, positions, for enforcement, they're contingent on these powerful elements of society. And so then you kind of wonder, could they ever play this robust role of helping weaker, less powerful members of society enforce rights against more powerful elements of society? Or would you really need kind of institutional reforms to get to that? And if not, what would you expect to happen as a response if courts did try to take on this role from the more powerful actors they've relied on in the past?
Yeah, that's a terrific set of questions. Andrew, should I go ahead and just answer that, or do you want to do?
Yes, please go ahead,
other
and we'll have more questions.
Yeah, no. So thank you very much, Charlotte. That's terrific. As is well known, there was a period from the mid 1950s, roughly through the late 1960s, early 1970s, in which the Supreme Court both looked back to Reconstruction era remedies that had largely fallen into desuetude, most importantly, the post-conviction habeas statute and Section 1983, but also created their own remedial vehicles, including the exclusionary rule for evidence gained in violation of the Fourth or Fifth Amendments, the Miranda doctrine, and the Bivens remedy for damages against federal officials as a across-the-board toolkit for the vindication of individual constitutional rights. So if there was a collapse, I think it's a collapse from a kind of a Warren Court legal imaginary that, at least it's my impression, still has a considerable grip on both the academic and the popular imagining of what it is that courts do. In response to the second part of your question, I think that the Warren Court constellation of approaches both to substantive and to remedial law arises because of a distinctive set of political forces, right? In particular, the forces that scholars like Derek Bell, the scholars who've described the importance of Cold War logics for federal attitudes toward the Jim Crow South, like Mary Dudziak, have charted. The interaction between the institutional arrangements created by Article 3 and developed from the ground up in the way that I've described in Chapter 2, with a momentary political constellation that favored remediation for its own reasons, not necessarily for the benefit of those who are obtaining the remedies, was the creation of a relatively progressive remedial architecture, right? My view about the way that doctrine arises is that it arises through interactions between long-term institutional arrangements and particular, sometimes fleeting, constellations or arrangements of contemporary political forces. And there's no per se reason why, even with a relatively weak and porous judiciary, one can't have a progressive coalition that turns that judiciary toward the project of individual rights remediation. The limit, though, to that possibility, which you allude to, I think depends upon the following. At some point, one might imagine a progressive political coalition that appoints, as I alluded to, right, a series of justices like Justice Marshall, like Justice Brennan, like Justice Sotomayor, who are committed as a matter of their ideology to fulsome remediation, right? Remediation is redistribution. At some point, that project starts to run up against the institutional interests of the judiciary as a body. And at some point, those institutional interests start to complicate or fight against that progressive mission. I don't think that we are anywhere near that kind of internal contradiction from emerging, but I think that that internal contradiction places a limit, an event horizon on the non-regressive, progressive, distributive possibilities of the judiciary as a source of individual remedies for government violence. I hope that I try to hit each of the elements of your question. I hope I did.
Very well, thank you.
Next, we have Seth Davis.
Hi, Aziz. It's good to see you over Zoom, and it was really good to have the chance to read the introduction and 2 chapters of this really interesting book. I want to ask a question that also goes to the idea of collapse, but it's a different question. I understand why the title of the book is The Collapse of Constitutional Remedies, but I wonder whether something like the regressive asymmetry of constitutional remedies isn't more of what the book is about, at least based on those portions that I've seen. And let me flesh that out just very briefly. So at page 3, you write, this book tells the story of a collapse of constitutional remedies for unlawful state coercion and the resulting asymmetrical treatment of rights and structure. And it's the first part of that sentence, so collapse of constitutional remedies for unlawful state coercion, that I want to ask about. Because it seems to me that, and as I think you'd acknowledge, structural claims can involve state coercion as well. And in fact, your Celia Law example could be understood as involving a question of remedies for unlawful state coercion. And that Celia Law example, when I compare it with the Baxter case, I think there's not really a puzzle here. I mean, what we're dealing with is a question of what's the remedy being sought, damages versus injunctive relief, who is the defendant, so against whom is the remedy being sought. And there's a long history of differentiation between, say, damages and injunctive relief. And so I wonder whether the story isn't more one focused on the way in which a constellation of rules about remedies and immunities and so on have resulted in this regressive asymmetry, rather than a story about a collapse of remedies for unlawful state coercion, and then a whole bunch of robust set of remedies for another class of cases. So I want to press on the idea of coercion and how it's playing out in the framing. And I want to press on the idea of collapse through pressing on the idea of coercion.
Yeah. So I've been told by other readers that I'm pressing my luck in framing a book for a popular audience with the word remedies in the title. I think I'd probably be taking several steps into the abyss if I called it the remedial asymmetry of injunctive and damages relief in Supreme Court jurisprudence, right? So the title is a function of the format. I don't think, however, that the difference between the treatment of the two cases I start with is a function of the difference between damages and injunctive relief. I mean, as you know, damages are also available, excuse me, injunctions are also available through 1983. And as I explore later in the book, there are doctrinal barriers that are as great or greater for litigants such as Baxter if they seek injunctive relief than as if they seek damages, right? The Lyons case being the most important of those. So I don't think that the difference between these two cases is the difference between damages and an injunction. The point that you make about coercion being an issue whenever the state acts is absolutely true, right? You know, the problem of coercion, you know, one could go further, is present whenever the state acts and whenever it fails to act, which is of course, the legal realists' observation. The distinction that I want to draw, though, between the two classes of cases is, I think, a more intuitive one. And the intuition is between instances in which dispersed field agents of the state are employing something that a non-lawyer would term violence, right? Coercion. And instances in which a centralized state body is engaged in regulation, right? I actually think that to talk about coercion or regulation basically captures that distinction for a non-specialist audience. And I realize that the distinction, if you were to press it, has ambiguous or close cases. But I think that the distinction between the field agent who has the capacity to inflict direct physical coercion and the centralized body that promulgates regulations or rules that have to be cashed out subsequently down the road by some field agent is an intuitive and a real enough distinction. I think it also captures a distinction between different kinds of parties. Parties that are generally seeking relief from regulation that, at least in the second half of the 20th century, itself has a progressive character, right? It's regulation that is meant to protect third parties from externalities in some way, shape, or form, as opposed to the individual objects of state coercion, where the distributive politics of policing, of street-level immigration enforcement, of the operations of federal security agencies from the FBI upwards, are at the very least more ambiguous. So I guess I would try and draw a distinction between those, or the distinction that I want to draw is between those two categories. But I'm trying to draw the distinction without getting entangled in details. I'm trying to appeal to an intuition that the readers, I hope, have that somewhat captures this distinction. I don't know if that's satisfactory or if it seems evasive to you.
Well, I'll follow up in an email, but yeah, I think that's it. Regulation versus coercion, I think, is a very helpful way to put it.
Okay. Next, we have a question from Mark Graber.
First question is, how do I unmute? Second, first, thank you very much, Andrew, and people for inviting me, and thanks to Aziz for a wonderful paper, and shout out to the APD squad. I think one finding of the American political development people is that courts in 1787, 1789 were not so much designed to be independent, but were designed to, in fact, carry federal policies into the states. And this generates two kinds of questions. The first is whether the late 19th century, the place where the second chapter ends, rather than seeing this as the independence of the federal judiciary, seeing this as the building up of the federal judiciary to carry the missions of a certain sector of Republicans in Congress into the states. And the second is, just as I think you're absolutely right to point out the Warren Court is anomalous, might it be said the Rehnquist and Roberts courts are anomalous and likely to be anomalous in their concern for limiting the federal government rather than the states, that in fact the judiciary as structured in the long run will be a better instrument for limiting states than the federal government?
Thanks, Mark. Those are both terrific points. I'm gonna embrace the first and fight a bit the second. I do think that in the 1780s and 1790s, it's right both to say that courts were characterized as independent, but characterized as vehicles for the furthering of federal policies, in the sense that to be an independent court was to apply the law as it stood, where the law was conceptualized as ex ante, certain and determinate. So there's, I think that by if you have the right conception of law in mind, there isn't a tension between the role that the courts, or the idea that courts are independent, and the idea that courts are an instrumentality of federal power. One question, and you might want to come back to me, or whether you might want to, we might want to talk offline, is were the courts in the early republic an effective instrument of federal power? The one domain in which that strikes me as being an accurate description is with respect to federal land policy, where federal courts did play an important role in settling disputes over the metes and bounds of federal title. But beyond that, the dominance of diversity jurisdiction in the design of particularly the lower federal courts limited their ability to pursue or reflected a limited ambition with respect to the employment of federal courts as an armature of national state power. I quite agree that as of the 1870s, what happens is the courts become instruments of a particular nationalizing project associated with the Republican Party, and I'm drawing here explicitly and with credit to Howard Gilman's pioneering work. And I think it's quite appropriate to describe what the courts are doing in the late 19th century as congruent with that Republican project, or that Republican vision of a particular kind of national state and a particular kind of national economy. At the same time, and here's where I think I disagree with the formulation that you offered, it well might be the case that a political coalition employs the judiciary as an instrument for its own particular time-bound policy ends, and in doing so, invests the judiciary with forms of authority forms of durable institutional capacity that go beyond the instant policy project. So the role and the sheer increase in the frequency of constitutional invalidations that we see from the 1870s onwards, right? And you've written a little bit about this, but I'm also here drawing upon Keith Whittington's work. The importance of the creation of the courts of appeals in the 1890s, the importance of the Judicial Conference Act in 1920 and the Judges Bill in 1925 go beyond the particular policy projects of the contemporaneous elected branch coalitions and speak to or create a more durable institutional capacity on the part of the courts. So it may well be that one can fairly describe what happens at the end of the 19th century in terms of a local political project, but it might also be that that local political project leaves more enduring institutional traces that have an effect upon the way that the judiciary can interact and affect both the national branches of government and the states moving forward. You know, as to your last point, so I don't know. I think that's an interesting. I think that what the idea that the role of the courts is centrally about or concerns the states, which is of course embodied in Holmes's famous dictum about judicial review, is a powerful description of the status that the courts have played up through at least the middle of the 20th century, the 50s or the 60s. What I do not know is whether what you accurately describe as a turn to the national and a turn to the project of constraining the national in the Rehnquist and the Roberts era will have an enduring effect, right? Once something is done, it can't be undone. Once the possibility that courts can be employed as a persistent constraint upon the policymaking ambitions of national coalitions that are elected to Congress and the White House, right? Once you have that on the table, I think your question implies that it can be taken off the table. And I don't see how that happens. And maybe this is just a product of my limited imagination, right? I don't see how once you have revealed the lower federal courts in tandem with the Supreme Court to be a powerful check upon particularly progressive elected coalitions in Congress's regulatory ambitions, that possibility somehow evaporates or vanishes, right? I think it's now on the table, and we're probably stuck with that. Is that?
Well, thank you. I agree with about 90% of it. I think the place I might disagree, and once again, might, because one of the things I try and do in legal history is I'm really accurate predicting the past, and I do not make predictions about the future that might ruin my percentage, is that, as you yourself note, to some degree, the Warren Court project, if not completely abandoned, was in fact severely scaled down to the point where even progressives are beginning to think, if Biden gets control, consolidates, maybe be less ambitious for the court. And so it does suggest that projects of particular coalition, not linked to more durable features of court structure, may turn out to be anomalous, at least in their degree. But again, I'm much happier predicting 1870 than 2070.
Yeah, I'll follow up with that unless, Andrew, you want me to stop.
Oh, go ahead.
What we're talking about here, I think, is the way in which institutional possibilities interact with the way that they're being leveraged at a particular point in time by a national political formation in ways that do or don't leave traces in the judiciary. And I'm not sure there's a global answer or a global solution to that interaction, right? I actually think that interaction, the conjunction between the institutional and the transiently political, is what I'm trying to map out over time, and what I think is most interesting in the APD school. To my mind, the most important legacy of the Warren Court is the warrant of institutional legitimation that is now embodied in the Brown decision, right? Brown now provides, the Brown v. Board of Education, now provides the federal judiciary with a cogent and complete answer to the accusation of anti-democratic meddling. And Brown has the virtue that's illustrated in cases such as Parents Involved, excuse me, of being almost entirely politically or ideologically plastic, right? Brown can, to misquote Jack Balkin's article on it, Brown can do lots of different things for you. But the most important legacy of the Warren Court, I think, is this hangover of institutional legitimation that is achieved by invocation of the Brown opinion in almost or every confirmation hearing of which I'm aware.
Thank you, Aziz. I'll jump in here with a question of my own, which goes back to the remedial asymmetry that Seth was asking about. Well, it relates a little bit to Mark's question about the extent to which we should expect the court to consistently, over time, rein in or attempt to rein in federal regulatory power. The question goes to the second half of the remedial asymmetry, not the one that is really the focus of the introduction or the chapters that we read, the court's hydraulic pull towards deregulation as you presented. And one way to think about this, the extent to which the court is structurally predisposed in this direction, or at least has been structurally predisposed in this direction in the modern era of qualified judicial independence that you are focused on, be to ask, how different would this book look if you had written it in 1994? And at which point we were well into that era of qualified judicial independence, but we had seen, at least since 1937, extremely little of the attempt to rein in the federal regulatory state, and not very much deregulatory activity at all on the part of the court. So what do you think? And if in fact the book would have looked very different in 1995, doesn't that suggest that it's easy to imagine quite a different state of affairs, even within the structural parameters of this era of qualified judicial independence that you described in the book?
Yeah, so that's a terrific question, Andrew. Let me start off by I think resisting an implication that is in your last sentence, and then going back and thinking about what, how to imagine the thesis of the book in light of the early Rehnquist court, or the mid-era Rehnquist court prior to, let's say, the sovereign immunity revolution. So it's not my claim, or it's not my, it is no part of either the claim or the methodology of the book that there's something deterministic about the institutional arrangements of the federal. There's nothing deterministic about the results of the interaction between Article 3 design and the institutional legacies of the judiciary that accrue over time. Rather, what that institutional residue provides is a repertoire that different coalitions of elected actors can employ and can employ differently, right? And how the repertoire is used, how the discretion that legislators have in designing jurisdiction, how the increasingly large discretion that courts have, particularly the Supreme Court has, with respect to where and how judicial resources will be allocated, both at the lower court level and in the court itself. This is a function of the Judges Act. They're not set in stone, right? They evolve over time. And what I'm trying to draw attention to is the possibility of interaction rather than the certainty of any kind of outcome. I think of the early 1990s as a period in which, on the one hand, the project of scaling back remedies that the Warren Court had articulated was well underway, but the project of constraining the regulatory state was as yet in its infancy. And a way of thinking about that is the judicial action here, I think, is in some fashion a lagged indicator of the preferences of appointing coalitions. So think about the preferences of the early Rehnquist court in terms of the approach to, on the one hand, law and order, right, state coercion, or immediate state coercion to accept and endorse Seth's point, and regulation in the Nixon administration, right? The Nixon, Rehnquist comes out of the Nixon formation. Nixon is very important, appoints 4 justices, many of whom are still sitting in the 80s, and whose imprint on the court is not yet washed away by the early 90s, right? The orientation of the Nixon administration is to constrain dramatically the Warren Court's efforts on behalf of minorities and populations that are regulated directly by the police, by immigration authorities and the like. But the Nixon administration is not committed to deregulation in the way that we think of the Republican coalition now, right? The deregulatory project actually starts with Carter and then really takes off steam under Reagan. So in the early 1990s, you have a set of justices at the Supreme Court level who I think are still pursuing a set of priorities that are calibrated as of the mid 1970s, and those priorities are involve the constraints on the courts in so much as they're giving remedies to the victims of individual state violence, but they're not yet. The courts haven't yet worked through and found their way to the anti-regulatory role that I think they start to take up hesitantly and then actually incompletely or maybe even in a way that fails in the form of the Rehnquist era federalism revolution, right? I think many early commentators thought, or many contemporary commentators thought the Rehnquist era federalism revolution foretold a dramatic constraint upon federal power. And I think it looks rather less ambitious or less impactful 25 years later. And where today we're seeing kind of not so much a reiteration of the federalism revolution, but a series of moves that are resonating through administrative law and through structural constitutional law, all of which have these structural separation of powers type themes behind them, that if taken to their logical limit, would be transformative with respect to the scope of regulatory power. Right? I suspect they won't be taken to their logical limit. I suspect they'll be taken further than they have been taken, that there'll be new and greater constraints imposed upon federal regulation. But I think that this iteration of the anti-regulatory strand is a function of justices now who are being appointed by post-Reagan or Reagan and post-presidents on the Republican side. And it's a product of what you might think of as a failed revolution in the 1990s that took a federalism form, and a new kind of jurisprudential experiment which has a separation of powers caption.
All of that makes a lot of sense to me. I'll just add one final observation, which is that it seems that the greater the flexibility, the institutional flexibility within the structural constraints or the structural arrangements that the book focuses on, the more it is the political regimes which come to power contingently at various points over the course of the story that are driving the bus than the institutional structure of the judiciary. And in fact, if the independent judiciary that arises in the early 20th century is equally consistent with the Warren Court, an everlasting Warren Court, if things go slightly differently in the political arena, and the current court, then I wonder how much of the causal work is being done by the structure of the institution as opposed to the evolution of regimes over time, as Mark was suggesting. But I will leave it there. We have another question from Tony Massaro, and we have Aziz until 11:15 Arizona time, 12:15 Central Time, 1:15 Eastern Time, if we have questions to occupy him for that long. But if we don't, we will also be happy to wrap up here at noon Eastern. So Tony?
Thanks, Andy. I think it builds a bit on everything that's been asked in terms of questions. Thank you for the paper. But I think I put it this way. I think it's amazing that the courts ever became more aggressive with remedies or more flexible. And it's partly institutional, but you know, when you think about what it had to happen first for the Warren Court to do what it did, your problem that you're focused on is why do the courts, why are they not more supple in providing remedies for violence at the hands of the government and through an individual rights regime judicially enforced? And my imagination is your baseline is would be physical violence. And I see at least 7 reasons, which you do too. First, the institution of slavery would make it almost impossible from the get-go for the federal courts to assume much of a role when you have, you know, baked into the original compact, you know, government and private physical violence. And it just really, I think, hobbles their ability to talk much about or be anything more in enforcing something with this structural problem built into the government that we got. But I think second to violence immediately, and this manifests itself in the Commerce Clause cases and throughout, if you're dividing up labor, seems like, you know, that's a crime. That's more quintessentially the state's business, not the federal government. Absent some really compelling reason to give it to the feds and create some federal right for them to enforce. Third, which is the story undertold, except among, I think, folks here, is they didn't have the power. You know, the Judiciary Act, they're more concerned ab initio with diversity and that type of discrimination. And so without subject matter jurisdiction, there's not a lot for them to do. Then you have, you know, no equal protection clause until after the Civil War. And I think a lot of the violence, the worst cases of it are sort of differentially occasioned. The old favorite is no army. When they do get around to thinking about policing things, they use flaccid things like the rational basis test. You know, things have to be completely outrageous and irrational. And even then, the judiciary thinks it lacks the power. And then you've got personnel. I mean, I don't think, from what I've read, anybody thought these were very cool jobs in the beginning of the Republic. These were not the places to run. If you, I mean, John Marshall may turn that around, but it was, we were just saying in Conlaw 1 this morning, more like the warm bucket of spit job with not a lot to do. So I think, and the people selected still today, I think, are inherently sort of middle of the road through the selection process and not particularly inclined to engage in redistributive kinds of thinking, let alone remedies. And so I think that all contributes to an institutional identity. Now, does it mean to be a federal court? And I think it's baked in. I don't know, chicken egg, but put the robe on, and I think that is kind of the set of predispositions, people, and so to me it is, how do we ever get out of it? And I think the Civil War is the huge explanation, and the astonishment we can't trust the states with these rights, and that doesn't even get into the difference between and damage remedies. So that's my 2 cents. It's supportive of what you're saying in the paper for sure, but I have a hard time separating all the vectors and figuring out what that means for the future. But thanks very much for the paper, as usual. It's just really a pleasure to read your work. Thanks, Andy. That's all I've got.
No, thank you very much, Tony. I think that was terrific and really helpful. I would throw in one more factor that into your account, which is the role the courts play in westward expansion, which I touched on briefly in my comments. In contrast to the relatively sparse engagement with the institution of slavery that the federal courts have, right up until Dred Scott, which is a different kettle of fish. The courts are directly engaging and directly facilitating the dispossession of native lands in cases like Johnson, right? Johnson is a case about the ability of the federal government to, Johnson v. McIntosh, is a case about the ability of the federal government to take, to serve as a monopsonist with respect to native land sellers, and then to distribute the land among settlers. It's an opinion written by John Marshall at the time that he had personal financial interests in Western land. Notwithstanding the sort of the hand wringing of Worcester v. Georgia, the early court's role, I think, in kind of the expansionistic, Frederick Jackson Turner vision of the American state is, I think, much more sharply felt in the interactions that the courts have with Indian tribes and with former native land than with respect to slavery. But that's entirely consistent with what you say. I touch on that, but don't go into it in the manuscript, just because it raises, I think, a complex set of questions and gets away from the interpretation questions that I described. I also want to kind of flip or emphasize the reason where I start that I start from where I do start, which is, I think most people. Well, let me say it this way. One draft of the introduction started with a list of statements by Chief Justices from John Marshall onward about how effective courts are in providing remedies for constitutional rights. And it started with that, look, we're the place to go if you need a remedy for a constitutional right, and then proceeded to debunk that. So that passage now is buried later in the introduction, in part because that way of starting felt upon rereading as a kind of gotcha moment that was cheap and kind of at the expense of these figures, right, Marshall to Roberts, and it felt like it didn't feel like the right way to start. But I am taking as a kind of a baseline belief of people out there in the world, not necessarily sophisticated law professors, but a baseline belief of people out there in the world, say the average New York Times or the average Washington Post reader, that courts do a pretty good job of addressing individual violations of constitutional rights. And look, if we just get rid of these occasional contortions in the law, like this, this qualified immunity doctrine, whatever it is, we're all good. We'll be on the right. We'll be back to the status quo, where courts can play this role of providing individual remedies in the way that Marshall, et cetera, up through Roberts suggested was the case. And the reason I'm going back through institutional history to constitutional design is to provide a grounding for a much deeper kind of skepticism about that possibility, right? So, and I think that unless one pulls this filament back through institutional history into constitutional design, the reasons for your or my skepticism about the possibility of the federal courts, I think it just doesn't become as clear. And then I have to say that I am deeply torn about the other question that you raised, which is what kind of arrangement with respect to constitutional right, what kind of arrangement with respect to federal court jurisdiction and federal court power would best conduce to the vindication of remedies where they are most needed, right? How would one do that, right? I can think of kind of local fixes involving jurisdictional changes, involving repeals to certain provisions of the federal code, involving doctrinal alterations, right? Extending the Federal Tort Claims Act to cover what are now Bivens claims, eliminating qualified immunity by statute, right? You and I could work through all of those things, right? How does one combine that kind of piecemeal reform into a judiciary that is so deeply oriented? Or how does one build that kind of piecemeal reform in an effective way into a judiciary that, for historical and for contemporary reasons of appointment patterns, is so deeply oriented against the project of checking individual level state violence and is so committed to these more progressive projects, right? So I don't have an answer to that question. The book doesn't purport to give one. But what I hope the book does is to offer readers a kind of explanation for why the project is so difficult in the first place. And I think that what the average person, and I'm probably deluding myself into thinking that an average person would ever pick up a book with, I'm going to go with Seth's title. It's going to be like something with 15 syllables in like the first, before the semicolon, and 32 syllables after the semicolon. I'm probably deluding myself into thinking that this is something that the average person will read. But I am at least sticking with this assumption that my goal is to puncture this easy optimism, right? And I don't have answers to how one fixes the problem, but if I can puncture the sort of the easy optimism and say, look, this really, the problem of a progressive set of federal courts is a really hard one for these deep reasons that are embedded in design and history. Right, and absolutely the reasons that you enumerated, absolutely, right. Then I think I have kind of done my job, right. I have, and maybe the way to think about this is what I'm doing is what used to be called critique by the Frankfurt School, right. I can explain why things are so difficult. I can't make things better, but maybe that's kind of what I think that's what law professors are for making people disappointed and hopeless.
We're good at that.
So Aziz, to be clear, I would definitely stick with your title over mine. Although I do think that there's, I do have the questions I had about the idea of collapse, but let me ask one more question here while we still have you. I think the question is both a question about your institutional history, so the political science claim that's at the center of the book, and it's probably also about norms in your normative analysis, to the extent this is a normative analysis. And you just touched on that a little bit. But what is the role of state courts within a system of providing constitutional remedies? And how do you think about the relationship between the state courts and the federal courts as it unfolds over time from an institutionalist perspective? So I could imagine a world, and let me be normative for a second. I could imagine being satisfied with a world in which the asymmetry, the regressive asymmetry is solved
Yeah.
through robust remedies at the state level that are not curtailed by federal immunity doctrines or other doctrines, right? For field agent violence, okay? I could imagine. So we haven't seen the whole book, but I'm not sure that I got a good sense of whether and in what ways state roles as institutions and the interplay, right? The federal courts in the federal system plays within your institutional history, or to the extent it's a normative analysis, your normative analysis.
Yeah, no, I think that's a terrific question. And let me answer it both let me answer it in two different registers. So in the historical register, as you know, up until the incorporation, up until the Reconstruction Amendments, there's not much by way of constraint upon state actors, and with the exception of this handful of habeas cases going from Stacey during the War of 1812 through to Tarbell's case after the Civil War, we don't have many instances of state courts enforcing constitutional rules against the actors to whom they applied, who are by and large federal actors. Okay, so the state courts are not doing much on that on the constitutional rights score up through the Civil War. Then we have this turn in the late 1860s onward to federal courts in the form of these new forms of jurisdiction. Remember, removal is one of them. Habeas is another. 1983 is another. Right. All of those projects are stymied by the limitations placed upon the substance of the Reconstruction Amendments in the civil rights cases and the slaughterhouse cases, right? There's ways of working around the Equal Protection Clause that we're all familiar with, right? So in a sense, just as the problem or the role or the question that you frame doesn't necessarily arise in quite the stark form that we might now perceive it prior to the Civil War, it doesn't really arise until the 1950s and the Warren Court, right? So in a sense, your question is a question of the contemporary moment, and it's not a historical question. And so that's the reason why the state courts don't play a role in the earlier part of the manuscript, in the history of the manuscript. Although maybe I need to add, a word of explanation on that score. The other register for thinking about your question is the following. Maybe a takeaway here is that when we think about the problem of street level government violence, whether it's inflicted by a police officer, an immigration officer, an FBI official, whoever it is, right? We shouldn't think of courts as the remedy. Or we shouldn't, the first move would be we shouldn't think of federal courts as the remedy, right? We should think of some other approach, right? That I think that has got to be right? And I think that's why you see in the literature on policing this turn away, led by Barry Friedman, from courts toward these kind of administrative remedies. Some of my own work has been looking at ways of using data to think about and to regulate policing. I think the kind of the limit form of that argument is defund the police. Right, and I think that running through that spectrum of non-judicial reform possibilities is this implicit but not actually fully worked out pessimism about federal courts, right? And then I think the question that you bring to the fore is, well, okay, we've given up. If you think the federal courts are constrained in this way, and you're looking for alternative frameworks or alternative institutional vehicles, well, are there ways in which state courts can play a role, right? Now, the one domain that comes to mind, and that it's sort of sharply presented by your backdrop, is in California you have a system of state courts that are actually pretty good. You've got a very good state Supreme Court. I have to say that because one of them is my co-author. It's a very good Supreme Court, especially Tino Cuellar. And you have a set of remedial frameworks in the form of state law, particularly in the privacy domain, right, that actually gives state courts a whole bunch of hooks for protecting and vindicating and realizing rights, both in immediately kind of retail remedies and more structural remedies than federal courts have. And absolutely, I would not want to rule out state courts as playing a role, but I think what I would do is I'd want to place them in a more contemporary context rather than in the historical context that I have in chapter 2. And I would want to think about them as one of several alternative institutional vehicles, and think about them in terms of a particular domain, whether it be policing, whether it be privacy with respect to social networks or the like. But I absolutely don't want to write them off in any way, shape, or form.
Thank you, Aziz. Do you have time for one more question?
Yeah.
Take us a little bit beyond 12:15 your time. We have a resident of the system, Judge Neil Wake, here with a question, and I thought it'd be great to hear from him quickly.
Yeah, that would be great. Thank you.
Thank you, Aziz.
All right, can you hear me?
I can hear you just fine.
All right, thank you, Professor. I have two related questions. One is qualified immunity.
Yeah.
What would you do to replace it? And second is federal habeas corpus to state prisoners. You criticize the stinginess of that, but what would you do to replace that? And let me just preface this by saying, in the district court, 1983 damage actions are, that's the bulk of our retail business. And so qualified immunity is a huge, huge issue. My own view, it's not quite this simple, but in pragmatic terms, I see qualified immunity as a requirement of making the 1983 claims intentional torts for personal liability by government actors. For municipal liability, the substantive rules are different. So you can get to municipal liability, but for personal liability on the government actor, it makes it an intentional tort. That's my view of it. Go ahead.
Yeah, no, I think those are great questions. I think, so this picks up on the last point you make. I would not treat individual, municipal, and sovereign liability as separate questions. I think that at the end of the day, we now know that because individual officers are pervasively indemnified, the judgment, the money in a judgment for tort damages is going to come out of the state's pocket, although it's going to come out maybe sometimes from the particular police department's pocket, and sometimes it's going to come out from the general revenues of the municipality. So I would think about the problem in terms of not in terms of qualified immunity, but in terms of regulating a police force in ways that produce information for the police force, allow commanders of goodwill to identify and eliminate officers who, it turns out, commit the small number of people who commit the vast majority of serious constitutional offenses, and that provide meaningful compensation for individuals who are in fact subject to constitutional violence. It's not at all clear to me that the best way to do that is through the courts, right? I think you can imagine, and in the workmen's or workers' compensation systems that developed in the late 19th century, we have models of non-judicial systems that actually play the kind of information forcing and compensation roles that that ideally the Section 1983 remedy would play. And I think that you can imagine a world in which the onus of compensation and remediation and improvement or resolution of unconstitutional practices falls upon the municipality, and the role of the federal courts is not so much to solve individual constitutional violations, but to prompt municipalities to do better. With respect to federal habeas, I think that the best solution in that domain was articulated by Eve Bransicki Primus, who argue for a return to habeas class actions. So what she argued is that habeas petitioners ought to be able to bring class actions, which were rejected in the 1988 case of Calderon v. Asmus. And in order to bring the class action, they need to be able to show that the constitutional violation in the state criminal process that they're alleging is systemic. So it turns habeas, again, from an institutional mechanism of remediation into a more structural instrument of dynamic institutional improvement. And I think that's a role with respect to which federal courts could much more effectively participate without the kind of caseload concerns that you allude to and that are particularly acute with respect to 2254 habeas.
Thank you.
Thank you. Thank you very much, Aziz. That will have to do it for us here today. Thanks to all of you for staying a little bit past our allotted time. And I hope that we will see many of you at our February event when Cristina Rodriguez of Yale will be talking to us about presidential power and immigration law. That's again, February 22nd at 3 p.m. Eastern time. Be well,
Thanks
everyone.
very much, everybody. Thank you very much, Andrew. Thank you very much, Charlotte.
Thank you.